Helen Suzman Foundation welcoming the decision by the Supreme Court of Appeal in the former president's parole matter. Yesterday, the SCA ruled that the decision by former Correctional Services boss Arthur Fraser to grant Zuma medical parole was unlawful and unconstitutional. In fact, the court ordering Zuma to return to jail to finish the rest of his 15-month prison sentence. For more on this, we're joined now by the Helen Suzman Foundation's legal researcher, Christopher Fisher, joins us via our video link this morning. And of course, Christopher, the Helen Suzman Foundation playing quite a pivotal role in what unfolded in the SCA just yesterday. I suppose the question is there a precedent for what should happen now?
Well, I don't think there is a precedent for what should happen now. I don't think we've known of a case where medical parole was unlawfully given and the offender was returned to prison with the opportunity to make an application in terms of which that unlawful parole was used as a motivating factor, because that's essentially where Mr. Zuma is at the moment. So I think it's another game of wait and see.
So the question that now needs to be answered, as I understand it, by the commissioner who currently is acting in the position, is whether that medical parole should count towards the 15-month jail term. Is that right?
Yes. Specifically, the Supreme Court of Appeal said he'll return to prison, and it's not a question for a court to decide whether that period of time counts to the completion of a sentence. It'll have to be in the hands of the commissioner in the course of any further applications that he makes. So Mr. Zuma will have to make use of the options available to him in terms of the applications for parole in the Correctional Services Act. And in the course of those applications, then the commissioner will apply his mind to whether that time counts.
The foundation, as I mentioned at the start of our discussion, playing quite a pivotal role in what happened just yesterday. The foundation was one of two organizations, as I understand it, right, that challenged the then commissioner's decision to release Zuma on medical parole and to override the medical parole board. How does the Helen Suzman Foundation see the next sort of decisions unfolding, Christopher?
Well, it's too soon to tell. We haven't heard word of an appeal, although an appeal seems certainly quite likely, given the fact that the effect of the order will be that Mr. Zuma goes back to jail. It's certainly an effect that Mr. Zuma would like to avoid, but we haven't heard anything about an appeal, although I think that, as I say, is quite likely. And then if he decides to comply with the order and return to prison and try and use his options in that way, it is simply too soon to tell what's going to happen. I think we are in somewhat uncharted territory.
You said that there's no precedent insofar as someone being granted medical parole unlawfully. But one does wonder, if it was anyone else, an ordinary person, you or I, how things would unfold, how these next steps would unfold.
Precisely. I think what we have here is a story of someone using their power and position to get benefits from a parole system that he perhaps shouldn't have gotten in the first place. There was reporting out earlier this week that Mr. Zuma was one exception out of 100 recommendations against medical parole that Mr. Fraser overrode. So there's definitely, at this stage, there's really no doubt that Mr. Zuma was treated as an exception in all of this. And it's a lesson, I think, for the rule of law that powerful people like Mr. Zuma shouldn't get and won't get benefits that ordinary people won't.
Does it end there for Arthur Fraser? I mean, the SCA ruling that his decision to override the medical parole board was unlawful and unconstitutional. Those are pretty strong words. But is that where it ends for him?
Well, I'm not sure. There certainly wasn't talk in the judgment, and there wasn't any hint in any of the applications before the court that Mr. Fraser himself would be the subject of any sanction. And I simply don't know whether that's being pursued by any other party.
Will the Helen Suzman Foundation be party to whatever unfolds next, insofar as the decision by the former president himself to take it on appeal?
Well, that's usually a discussion that we have when the decision of the opposing party has been made. So when an appeal, if an appeal is lodged, we will study the terms of the appeal, consult with our lawyers, and we'll we'll map a way forward from there.
The ANC in eThekwini yesterday said something along the lines of, that they do believe in upholding the rule of law. They accept what the court has had to say, but they also believe that it's not in the best interest of the country for the former president to go back to jail, because we know what happened in those 8 days in July when he was first sent to the Estcourt Correctional Facility. Surely that doesn't play a role in what the decision is from correctional services going forward.
Precisely. I think that holding legal rulings and decisions of imprisonment for breaking the law hostage to threats of political violence is, I think, a very dangerous place to move in South Africa. So I think that when making decisions about Mr. Zuma's incarceration, what really should be first and foremost is the demands of the law and how that law has responded to Mr. Zuma's behavior.
Christopher Fisher is a legal researcher at the Helen Suzman Foundation. Christopher, thanks very much indeed for joining us this morning. Just some background for you there. The foundation was party to that successful challenge of Arthur Fraser's decision to release the former president on medical parole and to override the medical parole board. It's a developing story. A lot hinges on what happens next, whether there will be an appeal, what the Department of Correctional Services does decide to do going forward. And as those developments come in, we will certainly bring it to you here on Newsroom Channel 405.